Get ready. 3 seconds. 2 seconds. Start. Heard the Learned Counsel for the petitioners. Also heard Learned Counsel for the respondent number 2. By this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioners defendant in TS number 20 of 2018 have prayed for setting aside the order dated 27/2019 passed by the Court of Learned Additional District Judge, Assam, in petition number 144 of 2019, whereby their prayer for rejection of the plain on ground of limitation was rejected. The petitioners defendant cited 4 grounds to assail the impugned order. Firstly, that the Learned Trial Court, while interpreting the provision of Section 3 of the Prohibition of Child Marriage Act 2006, completely failed to take into consideration the relevancy and impact of the definition of minor as contained in Section 2 (f) of the Prohibition of Child Marriage Act 2006 and the provision of Section 3 of the Majority Act 1875. Secondly, that the Learned Trial Court, while interpreting the provision of Section 3 of the Prohibition of Child Marriage Act 2006, held that a male would be considered to have attained majority only upon completion of 21 years of age, and thirdly, that the Learned Trial Court failed to take into consideration the fact that as the repeal and saving clause of the Prohibition of Child Marriage Act 2006 in Section 21 had not repealed the Majority Act 1875, ought to have taken into consideration of it, and having not done so has resulted in miscarriage of justice, and further, fourthly, that the Learned Trial Court omitted to consider the impact of wordings employed by the legislature in Section 3 of the Prohibition of Child Marriage Act 2006, in as much as the legislature in its wisdom had specifically stated completes 2 years of attaining majority, and had not stated completes 2 years of no longer being a child. Learned Counsel for the petitioners during argument laid emphasis on the above legal issues involved in the said petition. Per contra, however, Learned Counsel for the respondent plaintiff relied on the judgment passed by a 3-bench judge of the Madras High Court rendered in T. Sivakumar versus the Inspector of Police and others, reported in 2011 (5) CTC 689. The background fact of the instant petition is that the marriage between the petitioner number 1 and the respondent was solemnized on 12/02/2013. The respondent instituted a suit under Section 3 of the Prohibition of Child Marriage Act 2006, praying for declaring the marriage with the petitioner number 1 a nullity and for annulling the same with consequential reliefs as the respondent was born on 10/02/1996 and thus he was a child as per definition of the Hindu Marriage Act 1955, being 17 years 2 months 20 days on the date of marriage, and on the other hand the petitioner number 1 was more than 20 years of age on that day. That is not a child. In the aforesaid mentioned suit, the petitioners file an application under Order 7, Rule 11, read with Section 151 of the CPC, seeking dismissal of the suit on account of limitation as per the provision of Section 3 of the Prohibition of Child Marriage Act 2006. The aforementioned petition was rejected by the learned trial court via the impugned order dated 27/02/2018, holding that the suit was instituted within the prescribed period of limitation as specified in Section 3 of the Prohibition of Child Marriage Act 2006, inasmuch as a male attains majority only upon attaining 21 years of age and not 18 years as contended by the petitioner. Stop.